Have you ever bought something, got it at home, and then, you find a problem you really wish you'd known about? Or, hey, maybe you're renting and you're wondering, what happens if my landlord suddenly sells the building? Well, let's get into it. Because the law actually has some surprisingly strong answers for both buyers and renters when things just aren't what they seem. Right? We have all been there. You buy a car, a house, even just a phone, and a week later, some hidden issue pops up out of nowhere. It is so frustrating, and it feels completely unfair. And you know what? That feeling of unfairness, it's often backed up by the law. It all comes down to a very specific legal idea. In legal speak, the secret flaw is called a latent defect. Now, the definition here is absolutely key. It's not just any little problem. For it to count, it has to be hidden, it has to be serious enough to make the item less useful, and this is the most important part. It's not something you, an ordinary person, would be expected to find during a normal lookover. The law isn't designed to protect just experts. It's there to protect all of us. Okay, so you've probably seen or heard of buying something as is. In places with Roman Dutch law, like South Africa, they have a specific term for this, a voetstoots clause. It sounds a bit strange, I know. It's meant to protect the seller, but as we're about to find out, it is definitely not a get-out-of-jail-free card. So what this clause is really saying is what you see is what you get, faults and all. It's the seller's way of trying to wash their hands of any responsibility for those hidden, latent defects. Now, on the surface, that sounds pretty final, like the buyer has no options. But that is not the whole story. You see, even under the old common law, buyers weren't just left out in the cold. You actually had a couple of powerful moves you could make. First, if the defect was so bad that it made the item pretty much useless, you could call off the whole deal, return it, and get a full refund. Or second, if the flaw wasn't a deal breaker, but it definitely lowered the item's value, you could keep it but demand a cut in the price. The choice was yours. And this is where things get really interesting. What happens when a seller doesn't just happen to miss a flaw, but they actually know about it, and they just decide not to tell you? Well, a famous court case gives us a crystal clear answer on that one. Let's talk about the case of Van der Merwe versus Meads. So a house gets sold with a standard as-is clause. Nothing unusual there. But here's the kicker. The seller was totally aware that the roof had a major leak. And they didn't just forget to mention it. No, they actively hid it with the clear intention of deceiving the buyer. And the court's decision? It was a total hammer blow to dishonest sellers. The takeaway is simple and powerful. An as-is clause is not a license to lie. If a seller knows about a significant defect and deliberately hides it from you to make a sale, that clause is basically worthless. It's considered fraud. And in the eyes of the law, honesty always trumps the fine print. So that case was a huge deal in common law. But believe it or not, things have swung even further in the buyer's favor since then, especially when you're not buying from a private seller, but from a business. And this is all thanks to modern laws like the Consumer Protection Act, or CPA for short. The CPA is a real game changer. It creates something called an implied warranty of quality. What that means, in plain English, is that the law automatically assumes that goods sold by a business have to be of good quality, they have to work for their intended purpose, and they have to be free of defects. That old buyer beware attitude? Yeah, the CPA pretty much threw that right out the window. And the CPA doesn't just give you rights, it gives you a very specific, and let me tell you, a very powerful time frame to use them. It all comes down to this one number. 6 months. That is the magic number. For the first 6 months after you buy something from a business, you are completely in the driver's seat. The law says that within that window, you, the consumer, get to decide the solution. You can demand that they repair it, replace it, or give you a full refund. It is your call. And there's even an extra layer of protection. If you choose a repair and it fails within 3 months, the seller has to then give you a replacement or a refund. So, how does this play out in the real world? What does good quality actually mean? Well, let's look at a fascinating case with the Lazarus Motor Company that really put this idea to the test. So here's what went down. A customer buys a brand spanking new car, but not long after driving it off the lot, they start seeing spots of rust. The dealer's argument was basically, hey, the car drives just fine. It's fit for the purpose of getting you from A to B. They tried to claim the rust wasn't a real defect under the law. But the court said absolutely not. And its ruling is so important for all of us. The court made it clear that a defect isn't just about whether something works. It's also about whether it meets a reasonable standard of quality and acceptability. I mean, nobody expects a brand new car to be rusty, right? It's just not acceptable. And because of that, the consumer was protected. All right, so we've talked a lot about your rights when you buy things, but what about when you're renting? Turns out the law has some really powerful and often overlooked protections for tenants too. At its core, a landlord has three main jobs they have to do. First, they have to give you a place that's safe and decent to live in. Second, they have to keep it maintained for your entire lease. And third, they have to make sure you can have undisturbed use and enjoyment of your home, which is a fancy way of saying they need to let you live in peace. But here's the big question for renters. What if your landlord decides to sell the building while you're still living there? This is where a very old but very powerful legal principle comes into play. It's called hor hat verkoith. The name sounds complicated, but the idea is actually simple and strong. Lease takes precedence over sale. This means that if your landlord sells the property, the new owner buys it with you and your lease included. They become your new landlord and are legally required to honor every single term of your original rental agreement. They cannot just kick you out. Your right to be there is protected. Whew! Okay, so we have covered a lot of ground here, right? From as-is sales to consumer rights to the power of a lease. So let's boil it all down into a clear, simple summary of what you really need to remember. Let's break it down real simple. In a private as-is sale, your key right is protection from outright fraud. If the seller lies about a known defect, your legal tool is to take action for damages. When you're making a retail purchase from a business, your right is to get goods that are good quality and defect-free, and your tool is the CPA, with that awesome 6-month window for a repair, replacement, or refund. And finally, if you're renting and the property gets sold, your key right is that your lease must be honored, and your power comes from that hor gat verkocht principle. So, at the end of the day, whether you're buying a car or renting an apartment, the law provides a really crucial safety net. It's there to protect you from hidden problems and unfair situations. So the next time you're about to sign a contract or make a big purchase, just remember these ideas. You're not just a consumer, you're an informed one. And that, right there, is your greatest power.